You're going to be going to a deposition, which is a formal question and answer session. The attorney for the insurance company and your employer gets a chance to ask you all kinds of questions. This is a formal question and answer session because there will be a court reporter present. The court reporter is authorized to have you raise your right hand and swear to tell the truth, the whole truth, and nothing but the truth, just like you were in a courtroom. The other thing that makes it formal is the court reporter is trying to write down word for word every question and every answer. Because you're swearing to tell the truth, just like it was in a courtroom, you must tell the truth. In fact, if you told a lie, that could be a criminal offense called perjury. It's a felony, and you do not want to do that. There are some other rules to follow because of the court reporter's presence. These are technical rules that will allow the court reporter to make a good transcript of the questions and answers. In Arizona, for a workers' compensation case, the transcript that the court reporter makes is not part of the trial itself. In other words, this is not submitted to the judge to read. This is for the other attorney's preparation purposes. The other attorney wants to know how you will answer certain questions. The other attorney also wants to confirm information that they may already have. The other attorney also wants to pin you down to a certain version of events and facts. They do not want to be surprised if we go to a hearing and you say something to the judge that's totally different than what they understood to be the case. If you do say something different in front of the judge, the other attorney can use the transcript to impeach you. The other attorney will take out the transcript and say to you something to the effect of, "But you said something different to me during your deposition." And then the judge knows that you've given testimony before that was different. This is a problem because in order to be successful in your case, you want the judge to believe what you're saying. So again, always tell the truth. Other rules to follow because the court reporter is present is to be very patient. Wait for each and every question to be completely finished before you start giving an answer. This might sound obvious, but in normal conversation, we have a tendency to overlap each other. This is not a normal conversation, this is artificial conversation. So even if you think you understand the question and you're ready to give your answer, wait until you see the other attorney's lips have stopped moving before you give an answer. If you did not hear or understand a question, do not guess or do your best to give a response that you think the attorney is looking for. Instead, you should ask the attorney to either repeat or rephrase that question until you're clear. If you think that the question is tricky, there's probably something wrong with that question. It's poorly worded or you don't understand it, and it needs to be repeated or rephrased until you're clear. Because you're swearing to tell the truth, certain answers such as "I don't know" or "I can't remember" may be appropriate. In conversation with friends, we don't like to say "I don't know," and we'll guess at things or we'll give a response that we think is most probably accurate. But this is not a conversation with your friend, and you don't want to guess incorrectly and be accused of lying. So if the truth is "I don't know," that's your answer. I don't know. "I can't remember" often comes up when you're asked questions about dates or times or numbers. For example, there will be questions about the various doctors that you may have seen. When is the last time you saw Dr. Smith? Now, if you remember the date that you saw Dr. Smith, then certainly say the date. The other attorney will not be shocked or surprised if you can't recollect the exact date. And it's okay to say, "I don't remember the exact date I last saw Dr. Smith." But you want to give the attorney some range of time. In other words, you must be able to clarify if you saw Dr. Smith a day or so ago, a week or so ago, a month or two ago, 10 years ago, 30 years ago. If you simply say "I don't remember" and fail to give a response after that, the other attorney will take that as a sign that you may be a hostile witness, you may be an unreliable witness, or that you have something to hide, and you shouldn't give that impression. One thing that you need to also be aware of is that all of your responses need to be words in the English language. So for example, if you are asked a yes or no question, use the words yes or no. Do not give a common response such as mm-hmm or mm-mm. The court reporter will not write down sounds and body gestures appropriately. You may be prompted, is that a yes or is that a no? It's not to be rude, it's to make a correct record. Another example, if you are asked, how big was this object that fell on your head? You might easily try to respond, it was this big. But you need to use words to describe what you're showing with your hands. It was this big, about a foot wide. You also need to understand that we're not going to your deposition to prove your case or tell your story. You do not need to offer any information at all. In fact, you really don't need to say anything until there's a question. And you wait for each question, and then after you've heard and understood every question, you give a brief answer that honestly answers the question. You do not volunteer information about what happened next. You don't have to give lots of details or explanations. Usually, questions can be answered in 1 or 2 simple sentences. If the other attorney wants more information or more description or wants to know what happened next, then you wait for the attorney to ask the appropriate question and you address the other attorney's concerns as they like. You should also understand that you have not been picked out and you're not being picked on. This is a process that the defense uses in every single case. The deposition is conducted in every case where a request for hearing has been filed. The other attorney is not personally trying to attack you. The other attorney is not making this a personal vendetta to get you or something. You may feel as if you are being attacked or that you've been singled out, or you may feel that the other attorney is rude or asking inappropriate questions, but you need to disregard those feelings. You need to remain calm no matter what the other attorney does. You need to use the same tone of voice and the same volume, so don't start talking really fast, don't raise your voice, and certainly don't use any inappropriate body language. That will in effect give the attorney information that they think might help them at the time of hearing. They may decide that you present yourself in such a way that the trier of fact, the person judging you, is going to decide that you're a hostile person or that you're not to be trusted, that you're unbelievable because of the way that you testify, not just what you say, but how you say it. So try to avoid any sort of emotion. The deposition in a workers' compensation case is usually much shorter than in other civil cases. 20 to 40 minutes is standard. If during that time frame you need to take a break for the restroom or a drink of water or such, simply inform the other attorney that you're going to answer the question that they've just asked and then you'd like to take a brief break. At the end of the deposition, after the attorney has asked the questions, the court reporter or the other attorney may ask you, would you like to read and sign this transcript? And what that means is that you have the right to go to the court reporter's office and read through the transcript. If you think the court reporter accurately transcribed the question and answers, you can sign it. If you think the court reporter has made a mistake, you can make a correction and then sign it. You are not required to do this. It's a right, not an obligation. You will not be provided travel expenses if you want to do this. You will not be provided compensation for missing any money-making opportunities, and they won't even give you a copy of this transcript unless you purchase it from the court reporter. It can cost between $100 and $200 depending upon how many pages it may be. If you're asked this question, your response can either be yes or no. The technical term is waive. Realize that the court reporter is not an employee of the insurance company and not an employee of the other law firm. The court reporters are independent contractors. If you follow the rules of order, they'll probably make a very good transcript. If you want to exercise your rights, that's fine. It is your right. Expect many questions beyond what you think might be the important ones that relate to the issue in your case. Standard questions usually begin with a general background, things that can include where do you live and who lives there with you, how long have you lived there, are you married, do you have children or dependents, have you graduated high school or obtained a GED, did you go to college, trade school, do you have any certifications or licenses, a general description of your work history, up to and including the job that you were doing when you were injured. Secondly, details about the job that you were doing, things such as your job title, a description of your daily duties, your supervisor, your rate of pay, the number of hours that you were working. Obviously, a description of what happened to you when you were injured at work, followed by hopefully a chronological series of questions to find out what doctors you've seen, what medical treatment they've given you, whether the medical treatment has been effective, how are you feeling currently, what are your problems, are you working now, are you seeing doctors now, what kind of recommendations are you currently receiving from your doctors, and do you have future appointments to see your doctor or other doctors? Have you had prior work injuries before? Have you had personal injuries before? Have you had sporting injuries or surgeries? Do you have chronic health problems? Anything where you may see a doctor, take medication, or have been hospitalized in the past. These are all common questions, so don't be surprised. There are no doubt specific issues that will relate to your particular case, and you should discuss those thoroughly with the attorney who's been assigned to you. Good luck at your deposition.